No. Where's the bone? Where's the?
Go over to the chat arrow up the bottom.
Hang on, I want to stop the record.
Jared, I wasn't able to hear you. I think you're on. Are you intentionally on mute?
Same here, Lynn.
Can you hear me now?
Yep.
Yes.
But
Good.
with the needs and everything else that you've gone through there, you said. Try talking now, Renee.
It's traditionally on the.
Can you hear me?
Oh, you do? Yep, thank you.
Does it work? Great.
I gotta figure out how to get back to my support. I see her.
Either the third or fourth week of July. And then that means all of August open. August though, like some we had the first weekend of August. Banquet celebrating last season. Sunday is our preseason kickoff with our new team. And then Labor Day first tournament, so practices start.
Which is technically a new season.
Yes,
So they're one year behind.
middle of July. They used to be the middle of August, but it's been getting early in the middle of July, most. Teams are classes.
Yeah. Seems fairly. I don't try something. Even though they're, well, if you're still going. In July, but it's national. It's
A lot of things going on there yesterday, a lot of attachments, right? It was for some reason, that,
For today's.
yeah, for the first,
Kind of like that, do them all the same
I
day.
feel like there was 3 attachments, there's a bunch of them.
Speaking of,
Yeah.
Things being added for last second.
Yeah,
Well, yes, there was a limit, there was a little cutoff.
So Ricky, the kids are having a party now at home?
yeah.
And they used to buy it.
It's only 2 of them at home, so not too big of a party. Hi, Craig.
Sorry, I'm really.
No, you're fine. I wasn't sure.
How are you?
I'm okay. How are you?
Hanging in there.
Any news?
Not really.
And here, we had trials with our second class.
All right,
They were
waiting for
into
your listener, Jared.
and he just asked out. Other teams had already had their trials, whatever, but usually when you try out, they're not for 24 hours. They may need to one it's
I don't risk with that.
It's crazy, but this team might do it the second week, and this team might do it the third week. And then it's not like you can do all these different trials. Last year, I would see their house, they didn't do. But he was back in September, October, and just, you know, but then literally just held second to last round, like, is Randy still interested? As we're looking at like prejudice, so we had actually done a private trial before our national tournament last year, and we had to get an answer. Was never.
I like the structure, what I was doing.
Jen, we were way back.
There's 56ers in Madison, 3 clubs in it, Waukesha.
General.
Brooks and
And she said.
Alfred, Cedar. They would all offer, I think, 2 tryouts. And rarely was it they at least one. Sometimes it was one to be looking.
Like, have you said that you go there?
And
Oh, Dave,
players, probably
Is that
decades ago, coach knew where they were. So,
I
so
will say-
that they would be thinking, okay, well,
I thought it was
I
very.
got 15 girls would come to that. And I want to have it straight 20. Or the show.
We're told we have to share.
Oh, yeah, they're making songs. See if I can pull. Refresh and get everything through.
This is where it's at. How do you
Can you share screen so we can have the access to the agenda? I can't back in the board docs for whatever reason.
It's very.
Well, I like the fact that they're testing one with the, for the off. There's no need to come in and look at it.
You still have to log in. I don't know that too.
I don't remember that. But how much time do you consider? But you're sitting there on the side every, you know, the phone call. It brings some time to think about it. But that is, but it was awesome. Okay, what at the time that on random Thursday or Friday. So it's my deal. Just be watching sleep up out there. Oh, jeez.
Yeah, it's a motion.
Yeah.
We're ready? All right. Okay, time is now 5:34. I call this meeting of the Policy Review Committee to order. We will start it right away with letter A in under our policy discussion regarding administrative guidelines regarding transgender students. And there are some drafts that you see there on board docs. Is there a, do you want to start that discussion?
Yeah, I can start the discussion. So I want you to know that we work very closely with our attorney Renee, and Renee's here from Beulah Vetter. She's waving on the screen there for you. And drafted closely administrative guidelines. Part of those administrative guidelines, our main focal point was parent involvement piece. Okay. There is some discussion around choice for transgender classrooms. Right now, we have in the draft that transitioning students would have the choice to pick which restrooms they would want to use. All of our students who are on plans have chosen to use a unisex bathroom that is a private one-stall bathroom. So I just want you to know what our history is. However, the reason we put in the choice is because right now many of the court decisions lean in preference to the support of the transitioner. That is really open, and you can talk with Renee a little bit more about where do school districts align with that? What are some of our legal choices and options? But it's there for you. I know many of you have reviewed it. In the file is also a form letter that our liability insurance company put out there. That form letter went out to all clients they serve. They are for liability reasons. They say you can make choices on both sides. But right now, if the business decision you make is in support of all students versus transitioning students, more of the case law has been in support of transitioning students up to this point. So there may be some more liability that you're putting out there in regard to that. Again, our
Specifically to which issue?
to the bathroom usage issue.
Okay.
Yeah. But you can again talk about any of those issues with Renee. We have Renee here to help give guidance. But in the end, as a board, you'll have to make a decision as to what do we want for our culture? How do we want to put that? And knowing that, what liability are we opening ourselves to on either side of that? I mean, because there's liability on both sides. I will tell you the waters are shifting back and forth. There's no way not to have liability if anybody wants to get litigious. So with that, any questions, I would have you direct them to Renee, because she is more of an expert than I am. I just gathered information.
Anybody want to start off that? Go ahead, Tina.
I just have a question. Hi, Jonathan. I was just taking a look as far as like, as I was reading through the different documents and things like that, the model policies that are listed in there. Where, and I don't know who's best to answer this.
Sure.
It would be Renee. Like I said, I would direct all the questions to Renee. And you might need to speak up because again, the microphone is here, so.
So I'll put some clarification on the model
I can
policy.
hear really well, just so you know, I'm good.
It's actually model policy 33 that's in there. That's a resource from Wisconsin Institute of Law and Liberty. And that would be, an example of, I'm sorry, it would be model 32 rather. That would be student gender identity and parental notification and consent. Is that what you're looking at? Yep.
So is. Like, is that Neola? Like.
That's not
No,
Neola,
that's
it's a Wisconsin
Wisconsin
Institute for Law and Liberty resource. So
Okay,
it is a model policy that they're proffering as a way to address
Because of,
student gender identity and parental notification consent.
because it's a recent thing and because of the court cases
Yeah.
and that kind of thing, so that's why we're using that resource instead of Neola.
No, it's just a reference by which you can see how this is a divided issue, and there's actually court backing about the 14th Amendment, which is the inherent right of parents to direct the upbringing and education of children under their control.
Right, I have no issue with I'm just wondering why we're not using Neola. And where that one is coming. That's just my question, because we've been.
I don't think that, so
My question.
So the first thing is that there isn't actually a parent policy. There's this administrative guidelines and guidance, and perhaps there is a more of a story regarding that. But my opinion, there should be a parent policy regarding that because it seems to be absent.
Does Neola do guidelines? 'Cause this isn't a policy, this is guidelines.
They do have administrative guidelines. There's just not one that I've seen offered for this topic.
Right,
Yeah.
because I think there is a difference. Am I wrong? I mean, maybe I'm
Right,
missing some, but there is a difference.
Policy and administrative guidelines,
Right.
correct.
Right.
I guess I was just
So
confused because it's called policy.
because we have, the first document is the guidelines. Then the following documents are the consent form and the support plan. And those are kind of like along with that guideline, and they're talked about in the guidelines. Then there's the informational resource for a potential policy that you're talking about, Craig, and that's 32 and 33, the model policies. But Neola does not have a model policy comparable to the two that we have on there from Will, right?
Right.
That's my understanding.
Okay, yeah, gotcha.
The other part of it too is the Title IX update memo from the liability carrier is also a piece of information to consider. It actually lists out a number of different cases that are currently in litigation and have already been decided. That forms a recommendation of the liability carrier to encourage us to stick with more of what the current title, the executive order of Title IX is. Our district is enjoined, but there's also, as my understanding, that the Seventh Circuit Court has a similar alignment to the Title IX, the Presidential Executive Order Title IX. But that is also a circuit split between the 11th Circuit Court as well, where they have a different perspective on the executive order, the Title IX executive order. So we fall under the 7th Circuit Court in our state. So when we're looking at what our liability insurance is indicating, they're not actually telling us that, you know, they're not gonna cover us if we don't go with, specifically, gender, uh, biological sex for bathrooms. But they're emphasizing that we probably should stay with the Seventh Circuit Court. I just want to try to do the best I can to try to convey what's occurring here. And
Alana, how do you do? Anything else you would
Yeah, I
add?
was gonna say maybe she was. Renee.
Or excuse me, Renee.
Renee. and and and
Sorry. Renee.
I think that's a great description of it. So I can just give a quick overview by explaining that this is complex and there are a lot of decisions to be made. And we understand as lawyers that the legal aspects of this are only one piece of the puzzle, but that there are legal implications. And so our role is to be able to give you information so that you can make decisions. And we can't, can you hear me okay?
Yes.
Yeah. So that you can make decisions. And so we work with a number of different boards, and the decisions range from we are going to do everything that the Seventh Circuit is requiring right now and not things that the Kettle Moraine decision is requiring. We're going to try to do all those things at one time. We're going to do none of those things. We're representing a district where we're about to be, we've been before the Seventh Circuit because they chose not to comply with the Seventh Circuit precedent, and they are relying on the 11th Circuit and trying to convince the Seventh Circuit to go in the direction of the 11th Circuit. So there are a lot of pieces here. I would say that the three that we know about right now are that, like you just said, the Seventh Circuit, as it stands right now, is very much on the side of allowing any access to any restroom. And it's the lower courts have been unwavering on that point. And so as a result, there are many districts deciding to go that route. Parent rights is another area, and that's Waukesha County Court, the Kettle Moraine decision, very, very definitive about parent rights and honoring parent rights. And then there's a new case in Argyle that many of you may have heard of regarding teacher rights. And that's just starting to develop right now, where a teacher says, I didn't use the pronouns I was asked to use. And so I think that's a violation of my rights, and that has yet to develop. So that one we don't know about, but the other two we do. So the materials you have in front of you is from the perspective of if the district wants to go the direction of compliance with the Seventh Circuit case and the Waukesha County case regarding bathrooms and parents' rights and being very assertive in terms of parents' rights, it would look like what you have in front of you for those administrative guidelines. If there's a policy choice to go a different direction, then we can talk about the risks and benefits of going a different direction. But that's the overview of where we are, where we're starting from.
And hot off the press, this is an amicus brief from Wisconsin, well, a number of different institutes, but our clients, but one of them is Wisconsin Institute for Law and Liberty amicus brief that was filed August 14th. That was today for to petition this the Supreme Court to take up this particular issue in and of itself. So it's definitely something that is not settled. I mean, if you're looking at the Seventh Circuit Court, that is settled, but it's still being discussed in the court system.
And I'd say it's settled today. Like I said, we're awaiting a decision from the Seventh Circuit for a neighbor of yours. We're assisting. And so, again, things can shift at any time, but yeah, that's where we are today.
So there's really two main issues in regards to the particular guidelines that we have here today. One being the parental notification and consent, and then the other being the use of the facilities. And did anybody want to, start any comment about, the parental right piece that is discussed in our draft?
Just the parental right, or any.
Let's
Should
start
we
with
start
that
with that?
topic.
Perfect.
Let's start with
That
that
sounds like a
topic, the
plan.
parental right.
Parental right.
Where do you stand, committee, on parental right?
They need to be involved. That's where I stand. Can't.
As far as I read the policy, it was redundant in the sense, it's every single time you said consent, you had to then say, and if the case they're blah, 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 minor, then the consent of the parent. But otherwise, you know, you can save yourself some ink by just defining consent at the front of the document, but otherwise I think it was adequately covered via literally throughout every single aspect of the document. That consent implies that it's minors, including parents.
We wanted to
so-
make sure that there was no question.
In which case, if that was a gap in the previous policy, which I read once, but I didn't memorize it and I don't have it in front of me.
It wasn't as clear.
Yeah, that this one seems to be pretty crystal clear that the parents are going to be involved if it's a minor, in which case, no issue. And you know, I'll say I'm accepting of the way that it's written.
Okay,
I would agree.
okay.
Okay, so that issue,
Sam?
I did have one question about
Mhm.
that. Just about, and I completely agree. I think that, you guys, when you were working on this, it's very clear that you wanted to get that in the forefront, that you wanted parental involvement to be a primary
Mhm.
concern, which I know a lot of people in the district appreciate. However, in the second paragraph of section 1 or section I, Roman numeral 1, and in the first sentence of section 2, there is the phrase case by case basis. And specifically in that second section, when it talks about the following process being used on a case by case basis, I wanted to ask, does that provide the opportunity for any given person to, at their discretion, not inform parents?
No,
It does not? Okay,
No.
so they would be bound to inform parents of
Yes.
minors in every single case?
yes.
Okay, gotcha. I just wasn't sure because the argument that I heard from some people was that because it says case by case basis, then maybe this is a case where we don't have to do that since the notification of parents and guardians is contained in that lower section. There is one reference to it in that opening segment, but in the process itself, that all comes after the case by case basis phrase. Okay.
So my only, one of my concerns is that it's out of the norm for an administrative procedure and guideline to be just kind of out there on its own. I really find it odd that there isn't a parent policy that would kind of drive this sort of thing. And then it says at the bottom, the related policies, you know, student record policy, equal education opportunities, student discrimination, anti-bullying, and all of that. Great, but those aren't parent policies that, I mean, it seems like this particular administrative guideline is really kind of stretching, like the ability for it to take those policies and come up with a policy that drives our whole entire process around transgenders, how we deal with transgender students. I don't know.
So, yeah, and sometimes we do have some administrative guidelines that stand on their own, but reference multiple policy. And that's why we have them so that we can continue to direct and operate. If you want to write a parent policy that basically says what a lot of parent policies does, which is we as the board recognize that, you know, this is an issue facing our schools, and we direct the superintendent to write administrative guidelines in reflection of this policy, go right ahead. You don't have to, but then you would have a parent policy that would direct us to have administrative guidelines to run it. So
I do have a question kind of based on that.
Yeah, go ahead.
how is parents gonna know about this? It's not on, I mean, obviously today, but in a year, or 2 years, or 3 years, where is this? If it's not a policy, it's not in our policy board docs,
So it will be in, our policy board docs
okay,
as we finalize our administrative guidelines.
okay,
Remember, before, we didn't call out our administrative guidelines.
right,
They
right.
were like the policy 0.01,
Mhm,
right? Or something like that.
right,
As we move to Neola, Neola will have specific policies
okay,
and then they'll have administrative guidelines listed,
okay,
right?
Okay.
And so then people will be able to see those administrative
Yeah.
guidelines that way,
forgetting that that's.
right? It'll just be more organized.
Gotcha,
Before, in our current policy book that's still active, it's hard to even determine that they're administrative guidelines because they're the point, it says 0.1. Doesn't, I mean, people read it as policy.
policy.
Go ahead, Dan.
Renee, is it possible for us as a board to adopt the Assembly Bill 963? In essence, overriding the veto by the governor?
How's that on the agenda tonight? Like, how's that related?
Rights.
It's good, yeah,
Oh,
it's
for-
parental rights.
For the
Yeah.
parental
It
rights.
would be similar to the models that were put on like 32 and 33, specifically 32. This would be kind of something. that we
I just
could-
wanted to know how that was, I don't study all the assembly bills that are out there, so.
It's about
Sure.
allocating
Uh-huh,
funds
sure.
when there is a dairy farming competition at the same time. No.
Right, yeah, that's,
It's-
I just wanted to know.
So what we've learned lately is that anything is possible. So like I said, it's all about risks and benefits and a position that a board wants to take. So again, we work with boards saying we're going to do exactly what the law says in the form that it says it right now, this moment, and with no deviation. We have boards deciding that they are going to engage in what we would call intentional noncompliance. I mean, like they've just decided we will not comply. We've seen intentional noncompliance that is coupled with, we're going to make a statement about our intentional noncompliance, other intentional noncompliance that's a decision to not comply with a particular law or interpretation, and then just wait to see what happens, but be prepared to defend if that occurs. We've also seen boards seeking injunctive relief, enjoining DPI, for example, or the Department of Education from enforcing laws. You saw that in Kansas with Title IX. So, there's just a lot of different options. So all options are on the table. It's just a question of risk tolerance and what the district is prepared to do.
So you're
Sure.
answer Jared's administrative guidelines, tying them all to a parent policy. How many are there? Difficult, easy, makes sense. I know that about 2 or 3 months ago, we discussed administrative guidelines here at policy. We said they are the ownership of the superintendent. We struck one line from the first paragraph, I believe, to say, hey, you own it, you edit it, but it's part of the policy book, which means that we have purview. I'm
Pretty much, yeah.
Summarizing,
Mhm.
but I would say, Lori, similar to you or Craig, where does this reside? And if it resides in a very clean spot that everybody can get to, then maybe okay, administrative guidelines can exist separate, clear, I mean, not obviously, obviously separate. There's no 3420 or 1569 in front of it or anything like that. But how many are we talking about? If you had to create some .02s, are we talking about?
I don't
Okay.
even have that number off the top of my head,
Okay, that's,
but
I'm
There-
not
there'll be
against it unless.
there
they-
are a significant amount of administrative guidelines that we already have. And there's administrative guidelines that are draft, Neola guidelines that they would say you should think about having these as
Okay.
administrative
Well, like,
guidelines.
if function, if form starts to cost more than function. If it takes us so much resources to maintain the entire system in the book of administrative guidelines, and all it is for the purposes of maintaining a book, and we don't get any value out of it, then all we're doing is creating a bunch of work for no good reason. On the flip side, the concept of tying those together, I agree, makes sense that there should be not just in a footnote, Craig, but in the parent document that Jared, as you more or less succinctly said, hey, here's the policy. we, give the district superintendent the authority to create an administrative guideline. This is 1, 2, 3, 4, and that's 1, 2, 3, 4, 1, in which case I'd be happy to sponsor or to suggest that and create one just so that we can start having a home for some of these wayward administrative guidelines so that we know how they tie back into the policy.
And again-
And that they don't get lost, they're easy to find, and more specifically, they don't conflict with anything.
Right.
So
And again, what I would say is, I don't know that you need to do that step, because
That's-
once it's all in,
yeah,
right, and searchable,
okay.
through Neola,
So I'm not.
you would just be
advocating
creating
for
another
something.
document that
Yeah,
we
that's
need to
my point.
manage.
You're just creating another document, but if it adds value, then I'd be in favor of it. But if it doesn't seem like it's gonna add value, then, and it can exist on its own, then I'm not gonna push that issue. I just wanted to understand the.
And again, I don't care either way.
Here's my thought on that question, is that there's probably a reason why Neola chose not to have a parent policy on this right now. And I don't know what that is,
Fine.
and yet we have this. So, I think it has to be somewhere, and perhaps maybe Neola will come up with one in the future. Maybe they won't, but, I guess I struggle with the rationale behind why this exists in the first place. Because I'd like to think that when it comes to the parent policies that are cited on this particular policy, when it comes to anti-bullying and respect, we're gonna treat every student with dignity and respect, regardless of their background. And stuff like that, student conduct, that would be involved no matter who the student is. We're gonna
This document, Craig, has the playbook in it, legal name versus, Skyward name. There's another half a dozen things that no one would know intuitively because it's such an amorphous. It's best that we have a document. I'm not saying you were espousing getting rid of it altogether. I'm just saying as if I was any administrator in this district and I was approached by a student, and if I didn't have this, I wouldn't have any idea where to start or go. So I better have a document to work from, a playbook. Because if you don't give them one, they're gonna make it up. And if you think you can be wrong now, with the information we have, I guarantee we'd even be more wrong without one.
Well, to that point, I mean, I always kind of felt recently as soon as I was made aware that this exists, which that's a discussion for a different time. I do feel like, now that it does exist, it has to have a home, and so that people can refer to it. Now, I guess I would be in support of coming up with more of a parent policy that is a little bit more succinct on what the administrative guidelines maybe should be directed towards, but I mean, that's just maybe a logistic thing. Maybe we put the cart before the horse on this one, and we should probably do some cleanup of that.
I would support that. I just want to make sure we do that for all administrative guidelines. Because if we're gonna do it for this one, then you gotta do it for them all.
Well, I think the general practice is that we do.
We do. This is, I think, not necessarily a general, not necessarily, but
Not necessarily.
That's where I don't want it to become a distraction, not this policy, that effort.
right.
If Jared and Lynn are already going through, 1,000 policies, trying to migrate them to create another 50 more, just for the purposes of directing somebody to an administrative guideline, when they search transgender, it's gonna show up all of our policies, and then right below, it's gonna show up all the administrative guidelines.
Well-
And there may not be numerical relationship between the two, but they're all gonna be in the same spot that should be able to be found and queried.
But here's the other function of that. If it's a policy that the board approved, that's coming from the board, that's providing board direction. If it's a administrative guidelines, like administrative procedure guideline, that leaves administration on the hook for all of this.
No, not necessarily, because
We
our
already
board
ratified that policy that
Yeah.
says that it doesn't.
yeah, the board policy as it's written, basically says all administrative guidelines have to be approved by the board.
Right.
Basically giving them the force of policy.
We covered that 2 months ago.
Right, and we did that with our handbooks as well. So, that's why I said, I don't know that you necessarily need a parent policy. If you want to have one and you think it's more organized, then that's fine. The only other reason I think that you would have a parent policy is if you wanted to direct the certain kinds of work that you wanted us to look at and not look at in creating an administrative guidelines. For instance, you would say the board directs the superintendent to write administrative guidelines around this topic. And address these things, right? And do not address these things. I mean, that would be the only other purview that you would put in a policy that you couldn't affect in administrative guidelines.
Yeah.
That's the only thing I could think of.
Well,
there.
and this just goes back to the history of how this came to be. I feel that personally, this was not as transparent as it should have been. And I feel like I don't want to repeat that situation.
We have that problem with policy too. Sure, and that's why we're going through the Neola process, right? I mean, that's why we're going through all of this.
Diana, did you have a question?
Yes.
Sorry, I didn't keep me.
That's okay. It goes back to the thing about parents. And just wondering, yes, it says in the documents, the parent with the consent of the student, and if the student is a minor, the parents and guardians. Yet in some of the additional documents, not the guidelines, it doesn't state that. So do we do that purposefully or not purposefully? So we just need to be consistent if that's what it is.
In what other
Yeah, what
documents
other
and where specifically?
I'll actually, we'll see. I'll back to you.
If it is missing somewhere,
Oh,
which
yes.
I think it has been put in all of those documents because that is what we have been doing and we want to make it crystal clear that that is what we
Two
will
places where
continue to do.
I'll search that and I'll get it
And
to
then,
you.
okay, good,
Just to
thank
make
you.
sure consistent language. The other piece is that what we want it to be, that if a child turns 18 in October, the parent is not contacted. Is that consistent with what we do? I'm not saying it should be one way or the other. Is that consistent with policy as it is right now? Because the way this.
It's actually consistent with state law.
Okay,
Yeah,
I just want to make sure that that's.
even
what we want it.
the Wisconsin Institute for Law and Liberty also states rights under this policy transfer from the parent to a student who is 18 years old or emancipated under state law.
I anticipate that because kids can call themselves in sick, they can do, other things like that. I just wanted to make sure that we, as we're having this communication. I wanted to bring.
There,
So Jared, to your question, or Craig, to say move it along, but is the question about parental consent now, is the committee?
I think we
all on the same
codified
page
that.
on that one?
yep, it sounds like the committee is on page with at least the administrative procedural guidelines about parental consent. Is that?
Yeah, I am.
Yeah, okay. All right, so we'll move on to that second question about, the use of bathrooms, locker rooms.
And overnight field trips.
That the liability.
Well, liability does play into that conversation.
Yeah, it's still in the guidelines though, right?
Yeah.
It's still in the guidelines, but the guidelines as they are written, allow for a student to select the restroom that they choose and locker room. And WIA has some say in the sports aspect of things, but that's not.
So, in regards to the WIAA, I was doing some research into that. WIAA, if I'm not mistaken, they do not require that. They do not require that any school that is involved with their sports have anything of this nature in order to participate. It's just that if you are doing that, you have to let them know because they have to have that information for their purposes.
Any other thoughts?
I'm not typically risk averse. I've taken a lot of risks, financial, personal, physical, what have you. But if I'm gonna pick one side of the policy or not, I'm gonna get sued. I wanna know which one I got the best chance of defending. And regardless of my personal beliefs, and I won't even state what they are. If it comes down to the kid who is offended because there's a person other than their gender in their bathroom versus the non-gender kid who tries to gain access. Right now, whether it be Title VII or Title IX, or current case law, and from WASB conferences, as well as what our attorney might say, what our recommendations are, what anybody else says. It may be close, but it's not 50-50. I think it's, 60-40, 75-25, that you get a better chance of defending yourself and the 50,000 or so taxpayers who are entrusted us to protect their assets to stick with I'll call it the unconventional wisdom of allowing the transgender student to choose, because that's where case law currently is. And we have a responsibility more so than the people that we think elected us, or that the ones we happen to agree with, that we have to protect the assets of this district, is another one of our charges. And getting sued and losing is not a good way to protect the assets of this district and the 50,000 people who entrusted us to protect them. So that's where I would lean, as long as legal says it's about 75-25. You tell me it's 51-49, I might switch my opinion.
Yeah.
But
I
at 75-25, I'm gonna go that direction.
I guess
Renee, what are you gonna say? I'm sorry. Yeah, she's moving.
Yeah.
I was just gonna say right now, you can't hear. I was
And
just gonna
now,
that's accurate right now in the Seventh Circuit, that it's not a strong chance. Now, again, if we hear more from the Seventh Circuit based on that other case that I mentioned earlier, we will let you know right away. It could be that things shift, but we're not anticipating that's going to happen right now.
So restate that again, what your belief is in defending a position of denying access to a non-gendered student, or whatever you want to call it. Somebody who chooses to sign it.
Yeah, in the Seventh Circuit, the Seventh Circuit has been consistent saying that the student gets to choose. They said it previously. Last Thursday, there was an Eastern District case which covers part of your district, saying the same thing and saying that the lower courts aren't going to divert right now from the Seventh Circuit. So chances of success would be better either getting up to the Seventh Circuit, which is a long and, as one of you just mentioned, costly process, or going beyond the Seventh Circuit. And like I said, other districts are litigating that right now.
My thoughts on this policy specifically is that we have to get this right. This is knocking on our back door, quite literally. That the Kettle Moraine lawsuit is an example of that, where sometimes we have to make sure that we have certain things in place to protect the rights of parents and conversations with their children. Now, while that is the case, we also see that Title IX, as it's being enjoined across the country, and including our district being part of that injunction, that is actually a matter that is being discussed as we see. And I also believe that because there's a circuit split between the 11th and the 7th, there's enough there for me to believe that at some point the Supreme Court is going to have to decide a number of different questions that these cases leave wide open. So it's concerning. I understand and empathize with the perspective that we should take a financial approach to the rationale behind moving forward with this. But also in this amicus here, Elkhorn, 105 parents with children in the school district, took the Seventh Court at its word and submitted evidence that numerous students are in fact afraid to use the bathroom, knowing that a biological boy may be present in the bathroom with them. So they're actually having a concern about their safety and privacy. Multiple members also explained that they are considering withdrawing their children from the district to protect them. That's what we're up against. We're up against potentially a division in our community that could result in parents making other decisions. Now, when it comes down to it, the way I see it, there's two main arguments there. There's a financial consideration. Yes, you might get sued, but you might get sued from the other side too, right? Then there's a moral, ethical, and religious belief aspect to it that some people have. And it's also evident in the circuit split. I know where I stand on that.
Craig, only one comment. I
Sure.
agree with 100% of what you just said, except for the very first statement. Very first statement. We got to get this right. I guarantee you, we will not get this right. We will be sued. Doesn't matter what we do. We will be sued. It's a matter of, can you defend it? Now you can defend it to your household. You can defend it to your friends, your neighbors, the people you think who voted for you. I'm not saying that. I guarantee you, you will not be right on this subject. The best you can hope for is odds. Okay, that's it. So let's not try to convince ourselves that we're going to come up with something that's perfect and right, because there's not a single district or school district in this nation who's figured it out yet. And it changes every single day. So right isn't going to be in our discussion here. It's the closest we can get to right. And everything else you said, I agree with. So I don't have it. If we want to push the envelope, we push the envelope and we roll the dice. It's a matter, is it weighted in your favor or not?
Fair enough.
I have
Go ahead, Lori.
What have we been doing up until now? Have we been allowing them in the restaurant?
Yes, we've been allowing choice.
We've been allowing that.
We've been allowing choice, also at the locker rooms,
Say that again? Yes,
also in locker rooms. and
allowing
camping.
choice.
Okay.
Okay.
Choice.
100% of those who identify and have a plan
Mm-hmm,
have chosen to use a unisex bathroom.
okay,
And the reason they report that, and I'm just sharing information, you guys decide how you want to deal with it, is one, they themselves don't want to be in a space where they feel they're different and they're having to be exposed to that.
right,
And they don't want the current body they're in to have to do that to others,
okay.
right? So that's been
Right.
the reports they have for us.
Up until, is the choice based on these guidelines? I'm just trying to make sense and be sure I'm clear in that it's based on this. They have to do take this and we move forward with the guidelines the way they are. Are those students using the choice bathroom only the students that have parental permission?
They all
Or,
permission because.
100% of our plans have parental permission.
okay,
No, I think I want to clarify your question though.
could a
can't-
student just all of a sudden decide they want to go in the boys' bathroom if they're a girl or vice versa?
Yes.
Without, who's gonna monitor that?
They could, but again, that would go through a process by which they would be sitting down with their parent, they would be sitting down with their school team, and then they would make a change to their plan.
I don't
They
know.
have an annual review of their plan.
I don't know that is consistent with the Seventh Circuit.
I understand, but the way we have our administrative guidelines and the way we represent it for our students is that if you want to make a change, then come talk to us and we will change the plan.
Okay.
Okay. You know. I'll read this statement. This is, did the Seventh Circuit. I'll also offer this amicus. Did the Seventh Circuit mean to require that a student must have a medically diagnosed or documented condition? Does a student have to consistently live in accordance with this gender identity? Can schools require some sort of verification before immediately allowing any student that asserts a transgender identity to use the opposite sex bathroom? How does the reasoning in the decision apply to students who identify as non-binary or gender fluid? Whitaker doesn't address these questions and has ultimately created further confusion. These are some of the questions that are still left to be answered, and under the Seventh Circuit. So that's, yeah.
I'm sure what you read there, but on the page 1, paragraph 1, it says a transgender individual is an individual who consistently asserts a gender identity or a gender expression at school that is different from the gender assigned at birth. This involves more than a casual declaration of gender just for the day that I want to walk into the women's bathroom that day.
Right.
Oh, okay, so if they don't meet this paragraph for this policy,
Right.
then I don't exactly understand how the seventh and this one agree or contradict, but we would discipline a boy who walked into a girl's bathroom on a Tuesday just because they thought it'd be funny to look at some skirts. They wouldn't be able to walk out and say, but I'm transgender. That doesn't meet our policy and it would fall under bullying and harassment, et cetera, et cetera. But this paragraph, maybe we could beef it up a little bit, but the first 3 sentences in it are pretty clear who qualifies and who doesn't. Although, Craig, I'm not 100% sure how that does or does not relate to the 7th district's, what you just read. I don't have that document.
I guess
Does that agree or disagree with what you were thinking?
I think it contradicts what we have.
Well, this is,
but I'm not an attorney, and
this is what
Renee
we
is.
have. So
Yeah.
I'm saying,
Well,
So
this is,
7 contradicts what we have.
I believe so.
Okay, thank you.
But
So as a school board member, when I'm taking a look at, it's easy to get into the weeds on certain things. And I understand what our job is. And so as far as what we take a look at, I agree, David, as far as part of our job is to, financially responsibly protect the district from risk. And I'm not an attorney. I may have certain feelings this way or that way, but when we consult with the professionals, which I frequently look to the professionals for their opinion and their guidance, and that's why we're seeking it out. If they're telling me that, the less risky way to go, is this, because there are so many uncertain things. There are so many things in process. And, we don't have a crystal ball and we could sit here all day and say, well, what if this, what if that, what if, that's not going to get us anywhere. But I think as far as giving us something to go on right now, I would go with the side that's gonna, give us the most safety and the least amount of risk. As far as it sounds like adopting, this, what's written here. As far as the update and things like that, as far as following that is concerned. It's not to say that, we've come back for policies and things like that. If something changes in the litigious world of that and it says, no, we should go this way. This isn't written in, blood and stone. It's something that we can come back to, right? And change it the way that we would need to change it. That makes sense for us. But we have to have something going forward is the way I understand it.
I guess I agree with most of what you're saying in the sense that I guess I understand your perspective and I think they're valid points. But I also look at, nothing about this is safe. Like we have 6 in one hand, half a dozen in the other, when it comes to a liability, in my opinion, based on, if the 7th Circuit gets overturned, perhaps maybe that means we're not in compliance and that's a liability,
Then we make changes that we need to make. I mean, right? Am I wrong?
Go ahead, Dan, you had your hand up.
I would say,
There's more risks than just financial here. This is a slippery slope. They're in the locker room, the next thing they're competing, and we have more girls with concussions from getting hit with a volleyball by.
But hold on, Dan. We're not talking about competitive play right now.
I'm just saying, it's a slippery slope. The risk is we're gonna have very few girls going out for those teams. And pretty soon Title IX is gonna look a whole lot different than it did when it first came about. And we're gonna lose kids from the school district. That's a risk too. And I've never been successful when I've made a decision based on fear. If somebody's gonna sue me, they're gonna sue me. So I think we have a greater risk of losing our public school footprint if we don't take a stance and do the right thing.
Yeah. Thank you, Dan. Who was next? Was it Sam?
Yeah, I mean, I do have a lot of questions. I went over this, but I think that most of them, the issue that we continually run into is the fact that things are divided. No matter what, there are going to be people who are not satisfied, and the winds are going to blow in different directions, pretty much constantly. It's going to be one way one day, one way another day, and you don't really know how it's going to turn out until you get there. But I think that there are questions that you need to address if you're going to do something like this. If you're allowing, if you do have a situation where you're allowing a male to go into a female locker room, are the parents being notified? Are the parents of those girls being notified? Do they know that there's a male in the locker room with their female daughters? Because that is something that my constituents care about a lot. I've gotten more messages, phone calls than anything else about this policy that's coming up, and it's people's concerns about ambiguity. There's lots of people who are asking me about the potential fallout, the issues with, although it's not in this policy itself, the concept of the purpose behind someone's gender expression is not a determinant of the validity of their choice. And that opens the door for exactly what we've been talking about, people using this to their own malicious advantage, like that young man in Loudoun County did when he raped 2 girls in bathrooms, and the school covered it up both times, which was terrible. That's a really serious issue that we need to avoid, because that is a lot worse than dealing with people who are feeling frustrated. That is a real consequence. And the chance of that, I think, is so serious that we have to address it seriously. The solution that I would propose, that I think is clean and neat, is you organize locker rooms and bathrooms by sex, by biological bodies. You do not organize it by people's gender identities. And you spend $20, $40 to buy placards for the bathrooms, and you replace the word man with male, and you replace the word woman with female, or something like that. I think that would make it clear and simple. The bathrooms are not divided based on people's gender expressions, based on people's gender identities, not based on social norms. They are based on people's biology.
I just want to make sure that you're aware, Sam, that the whole argument behind Title IX right now is under the definition of the word sex. So, and that's what's being debated. It's biological sex, or what the definition of that word sex is. And the original congressional legislation of Title IX was intending that sex means sex.
Yeah.
And that means male and female. And the presidential executive order that's recently that we're enjoined on is it makes that sex, it convolutes the word sex in a way.
Does it actually, is it about the word sex, or is it about the concept of discrimination on the basis of sex? Because I think it's built off of the Bostock decision, right?
It's based, it's the definition of the word has been changed as a result of.
Okay, I guess I would need to look into that. My understanding was that the decision that they built the Title IX changes off of was that if you do not allow a male to enter a women's room because he is a male, you are discriminating against him on the basis of his sex being a male, because the argument goes that a male can have the gender expression of a woman, but it's not that a male can be a female. That's a non-contradiction issue. Does that make sense? I know that's.
Maybe the attorney would be able to answer that.
I mean,
Renee, yeah, can you tell me about
The
that?
question right now is whether the new regulations, the 2024 regulations, include gender identity in the definition of sex. And so it's covered by Title IX regulations. And then there are a couple of different ways that couple of different pieces, and I won't go into too much detail because I don't know that everyone wants to get this much into the weeds, but we talked a little bit about the fact that the Kansas case is relevant because you've got your high school and one other school on the list. So the Department of Education can't enforce the new Title IX regulations that include the gender identity definition. And that's one piece of it. Then there's a whole nother body of law having to do with the Loper case from the US Supreme Court. And that calls into question whether or not courts will be bound by the answers that they're not. And so we're going to see what happens when courts start interpreting regulations of all kinds and sorts, not just Title IX, but IDA 504, because the Loper case essentially said that courts are no longer bound by agencies' interpretation. So that's a whole nother area. So, I mean, it couldn't be more unsettled.
Thank you.
So
Diane had unless you had something first.
I just wanted to put on the table, one of the things that many school districts across the nation have thought about is if they're going to be thinking about the assets and protecting the assets of the taxpayers and using those assets in a way that don't feel like they're gambling one way or another on this issue. They've instead invested in a winning situation that has resources available to anybody. They just create unisex restroom areas and unisex changing areas. They're all over the place. You guys have seen them in many places. And
the new YMCA is going to have all unisex.
The new Y is going to go that direction. We could make this a real non-issue for people, but it would take an investment of funds. If we get sued, it's an investment of funds.
So can you explain that to me a little bit? You're not proposing, and I'm not sure what the Y is going to do, but I know at the YMCA they have like family changing areas where everyone has their own separate little changing rooms that they can go into. Is that the kind of scenario you're proposing, or are you proposing communal changing areas?
The communal part is where you put your clothes in the locker after you've gone into the private area for you and or your family member, right? The other thing I do like about that is right now, I mean, we've got our same-sex students doing awful things to each other, fights and other things in a place that is unvideoed, whatever, right? If you create essentially closets where one person can maybe get in and change, do what they need to do, use the restroom, and then they come out, right? That can be better. The drawbacks that I've been aware of this situation have been on the female side. You let's say you have your menstruation, it comes out of the blue, right? And you want to go into a place where you can maybe talk and get some help from a friend real quickly and not be embarrassed, right? It's really hard to do that if you have a small stall, right? So there are some drawbacks to it that we would have to think through or think about. But some of the other positives are we don't even have this conversation anymore, right? There are other things that we could think about. And I'm not saying that we have a solution for that right now, right? Because that would take a time and investment, but it would move us in a direction where this becomes a non-issue.
Diana first, sorry.
Jared took mine.
Okay.
With, as far as the unisex part. And my question behind that, making the suggestion A, but the question is, are we bound by law right now to have the students in non-gender assigned bathroom allow that permissible piece? Or can there be a separate area in the meantime until we could do something like that? what does the law state? Because it'll be a bit before we can get to there,
That's more for Renee.
the meantime.
Yeah, I would, that was. gonna be
Renee,
one of my-
what are your discussion points on that?
So the Seventh Circuit currently says that students have choice, right? So that if all students have choice, that transgender students also have choice. And so, but that's it. There's some other pieces we were talking about earlier that the Seventh Circuit hasn't addressed, but in a nutshell, that's what the Seventh Circuit says. And again, districts are doing different things with that, right? They're based on their culture and climate, based on their risk tolerance, based on a lot of different factors that are separate from the law. But that's what the Seventh Circuit says right now. As pointed out earlier, different circuits say different things, and that could shift. But we're in the Seventh Circuit, and so that's when somebody asks about being bound. We know that lower courts are going to listen to the Seventh Circuit. We know that, but at the same time, every district needs to make the decision that it makes for itself.
And when you say choice, you mean the choice between the bathroom of their gender assigned at birth, the choice of a unisex bathroom, or the choice of their gender, what gender they're identifying in. It's not
Right.
just choice, right? It's all three.
Right. We're looking at choice as opposed to, all students who are transgender. That's why you see the words case by case in a lot of administrative guidelines in a lot of districts, because the idea is that we're working with a family to come up with a plan, and that plan doesn't have to be the same for every student. There's flexibility. Yeah.
The other part to my question, and I agree with the statement of we have to be fiscally responsible. We have a responsibility as a district for that. We also have a responsibility for the safety of our kids. And I'm struggling with that because we have safety of our transgender students. We have safety of our general population. And I don't know where, I understand the math game. David's an engineer. He's going to err on the side of mathematics 100% of the time. I don't know if that's always best. I'm not sure. So I'm willing to listen to more of the discussion in that. I know my husband would be saying the same thing, because I come back to that emotional part of, what if it's my little girl in the back? What if it's my little girl for the first time seeing genitalia they've never seen before? And how do I explain that as a parent? How do I explain that as a board member? So there's an emotional part to this that carries in there. So I understand the fiscal part, and that's why I want to see, okay, bound by law, where are we bound by law? And if there's a way that we can maneuver, I'm okay with that too, because sometimes there's a little gray.
And so I hear your statement, and I don't necessarily disagree at all. I guess my concern is, yeah, we have a liability of being potentially litigated because we change, according to what the Seventh Circuit is putting down. But then we also have, on the other hand, strong liability, even a worse liability if something really bad happens, in one of these facilities. And I know I couldn't live with that, as a consequence of something that is still being settled in court. And I don't believe we're in bad company when there's clear circuit split here. But I do hear what Renee is saying. The lower courts have all fallen down under the Seventh Circuit. It's a really difficult thing to consider, but if there's a way that we can word this so that gender neutral bathrooms are accessible for that particular circumstance, and that that it's
Said it's, you have to give that.
yes.
So that's not a.
But I mean, that to me, that would be a little bit more palatable, even
So
going against. Yeah, go ahead.
Yeah, I just want to interject because I'm giving you information. We're giving you information about what the Seventh Circuit says. And again, I went through before, there are a lot of options and boards will make different decisions. So if a board says this is what we want to happen, we just want to make sure that you're aware of the risks and benefits, right? And that you're having the discussion that you're having now. If the board's committee and then the board decides, here's what we want to happen, then we can help support with the language and the policy language to essentially put into effect whatever the board's choices are. And I think that's an important piece. So we can answer questions about the law. You think about that, you let us know which direction you'd like to go, and then we assist in making that happen.
Thank you. Who was first? Was it David or Tina? Tina? Go ahead, Tina.
Just as far as an information piece goes, I mean, I don't think, agree. We shouldn't, be, pushing fears and things like that out there. I can pretty much guarantee that situation that Sam described, that more often that there are the same sex things going on, there's more vaping in bathrooms, there's more sexual assault through, phones and dating and outside of school that is ever going to happen in those kinds of situations. Pretty much absolutely guarantee it. So I just, I know it can be a sensitive topic, but I guess I just want to put people's minds at ease that, a lot more sexual assault, unfortunately, happens in all those other situations more often than these circumstances.
Okay. David?
I'll say I'll go last if people keep on.
Okay. Oh, go ahead, Lori.
My question is, we talk about choice, which I respect 100%, but if you have a girl and her choice is to be in a bathroom with only girls, how are we not taking her choice away? What are we going to do in that situation? If it's a belief system or a parent knows that there is a student, and while we can respect the boy wants to be in the girl, for the transgender, I can respect that. We still have to respect the other child. And I think that is where we are really up against a wall, because I don't know what the right answer is. You're darned if you do, darned if you don't. I think I don't know. That's all what do we do in that situation?
What I've shared with you is you have to think of all the things that you're looking to do, right? In that situation, if you want to equate those as similarly moral and similarly have the same rights, right? Then you have to look at other things, and you have to look at where your risk tolerance is,
Right.
Right. Then the committee, the board as a whole, right, has to say, how do we want to handle risk? I believe I was talking to a citizen the other day, and they talked to me about decisions and risk making, and it was true. The person said, you go talk to the accountant, then you go talk to your lawyer, and then you make a business decision. So what's going to come down to?
Yeah.
You guys have to make a business decision on this, because you're in the middle of a moral storm right now. That winds are blowing back and forth in, right? The only way I can help you is by telling you what the most current information is, having you assess all that current information. Part of that information, if it comes down to one thing, it would be risk tolerance and how much you want to have as risk tolerance for what you are in charge of.
Thank you. Who was next? Was it Sam or?
Well, okay, you're on the committee, but okay. Yeah, no, I think you guys kind of voiced a lot of the things I was thinking about. I have one quick question for Renee. Renee, would it fall in line with the Seventh Circuit? And I know that I'm asking the question for my clarification. I'm not just trying to repeat things. Would it fall in line with giving choice to students because I see that on letter D under Article 2, the way that we deal with bathrooms is different than the way we deal with changing rooms, right? Locker rooms they don't say consistent with gender identity, consistently expressed by the student. So locker rooms do not have that same clarification in the language of the guidelines right now. would it be possible for us to take out the phrase consistent with gender identity consistently expressed by the student in the upper half of item D there? Would it, because we are still giving choice to the students, we are still giving the student the choice of using something consistent with biological sex or consistent with, or the private bathroom changing area? Or is that something that the Seventh Circuit is very specific about being insufficient?
Bathrooms has been the focus. And so we're seeing districts treat locker rooms oftentimes differently than bathrooms, because all of the focus has been consistently on bathrooms. So when we talk about these cases, that's what we're talking about. So I think the answer to your question is that we do see more flexibility in other types of settings like locker rooms.
The Seventh Circuit specifies that for bathrooms, they've upheld currently that all three choices must be given, not two of the three.
Yeah, that's what's happened. But in those circumstances, so some districts are arguing that the difference is, well, you should be looking at the 11th Circuit, for example. But all arguments, and you'll see this in the Elkhorn case too, are based on the specific facts and circumstances related to their district and students in their district. And so, there could be a wide variety of different circumstances that lead to decisions regarding overnight trips and locker rooms and things like that. But yes, when we're talking about bathrooms, then the specific facts and circumstances that have been in front of courts in the Seventh Circuit, they have consistently so far, based on those circumstances, decided that choice was necessary for those particular students. And then we'll see what happens. So, Elkhorn's a preliminary injunction, right? There's a lot to come.
Can you clarify, I mean, because that injunction could go both ways, but I don't know how many people understand that the injunction in Elkhorn is actually specific towards the Elkhorn School District proposed a policy similar to sex at birth policy, rigid for those particular bathrooms. And the injunction is for their students to be able to use a bathroom of their choice. Is that a correct statement?
The injunction is only for that one student to be able to use bathroom of choice. It's a preliminary injunction. And like I said, there's more to come. So when we look at injunctions, we look really carefully to see, does that injunction apply only to the student who's the complainant, or does that apply to all students? And so the injunctions that we've seen recently apply to the student who is bringing the action. And so that's something to watch.
Thank you. That's good information.
Thanks. We're in, not a problem. Another 2 hours in, we're gonna be in the same spot. Okay, we're not gonna get there tonight. We're not gonna get there with the 7 of us. It's gonna require. I don't have any problem. We can stay here until 11 midnight, doesn't matter. I'm fine with that. I would propose, I'm gonna rephrase it. What do you think? This policy is pretty consistent with the 7th district. We can write another policy that pushes a couple of envelopes. Says, no, we're not going to do that. We're not going to do that. We're going to do this. Might get sued over here. And you have 2 more or less competing policies. They both have all parental consent in them, as we already agreed upon. And now you have kind of 2 documents, and you give them to the board for a vote. And you can have this discussion then, everybody goes around the table, says whatever is on their mind, and then you just vote on it. And then you know where we stand. And you know what the risks are. You know what you're up against. You know hey, this is the parents who are going to be happy about it. These are the parents who are not. These are the ones who are going to have to suck it up and maybe go into a bathroom with 10 girls and 1 boy. It could happen, or vice versa. But I mean, we haven't even started wordsmithing this yet, let alone agreeing on which direction we want to go.
Right.
And given that it is fluid, call it wins, call it precedents, call it whatever the court does tomorrow, I already said, Craig, we're never gonna be right. So if we need to get to a resolution, because right now, Sarah, is this orders in hand? If somebody asks for a gender transition program tomorrow, would this be the one that we would break out, or would we either break out the one without the parental consent? So if we're
That's
gonna
the
break,
one that we have.
that's okay. So at a minimum, we should approve this one, even though that it's a work in progress, because we think we're all in agreement that we want parental consent in it. And right now, if somebody stepped forward tomorrow, we don't have to consent their parent or whatever the last document said.
Well, we don't have to, however, that is what we have consistently done.
Okay.
So I will say that the reason that this came up was during one of the strategic planning sessions, a parent had a valid question, and I said, no, this is what we do. And then I went back and I looked at our documents, and I'm like, these documents, one of which that I had never seen before, I was concerned that our practices as we do them was not reflective in what was written. What was written was a bit vague and left out a very important piece, which had to do with parents and guardians being heavily involved in this and providing that consent and knowing what's going on and knowing how to, if there was a change or had some concerns or, what to do. We needed a playbook that really did meet the needs of what we were doing and what we've been doing. It doesn't mean we're going to change what we're doing, but that old one has been used. This one lays it out clear.
Okay, so my comment on that is that at a minimum, we owe it to either that parent, to Sarah's work, to the agreement of this subcommittee to at least push forward that portion of this document that changes the parental involvement in the decision. And as Jared has said before, let's not let great be in the way of good. So at a minimum, let's get that off the docket and push forward. At the same time, I'd be really interested whether legal or somebody else could put together a document that was, I hate to say, as permissive or as stretching the bounds of a court as possible. If not the seventh, pick a different one. And if they're diametrically opposed, well, then we have at least some precedence on our side, because we're not attorneys, we're not judges, we're not, we're not even think tanks. We're just a bunch of people that, happen to be dumb enough to put our name on a ballot. So am I wrong?
He's like,
I mean, I'd like to think that we're a group of individuals that are doing the best we can.
and
Exactly.
And we are
And I'm not disagreeing with that. The point is that even with that, Craig, we will be here for another 4 hours because we've not gotten anywhere except for we all agree parental consent has to be part of it.
Right.
So,
agree, but we haven't had this discussion at all.
but we don't even have an alternative document to look at to see how drastically different from this one it would be and what toes are we putting over the line.
Right.
We know that Title VII and Title IX says if you're going to give an option to one gender or sex, you got to give the same options to the other gender or sex. Which means that offering unisex for somebody who's transgender, but not the one that they declare, I'm gonna say that's a big no-no across every single court. So you can suggest it in that alternate universe document, but you will lose every single time because there's nobody who supported that yet. Not a single court. So now it's about whatever is else in here. I'm not saying that I don't find 90% of this is objectionable when I sit at the dinner table at night. I'm not thinking about the dinner table. This is more than just, two bulls in a sheep voting what's for dinner. And frankly, we have a lot of people to look after, not just the ones that we choose to dine with and hang out with. And we hear from them every single time at the public comment. I'm not saying it's 50-50. Come close enough to think that it's a 90-10. There's a lot of people who are vested in this thing, protecting their kid who wants to choose. We represent them, not just the ones we think voted for us.
Yeah.
So I have no problem with a different document. I do have a problem sitting here for 4 hours talking about it and getting nowhere. So I'm trying to get a way to get to a point where we have two things to look at and an understanding by the full board what our risks are with each.
If we were going to design an alternate document, Jared, I did a lot of work going through this, looking at the cases that are currently in court, and I made a number of notations about things that I would maybe alter from that perspective, like an alternate document, like you were talking about. And I appreciate that idea. I think that's a really smart idea. Present both of them before the board, let people vote the way they will. Who would we talk to about crafting an alternative version of this.
Just send me your thoughts.
Okay.
We'll work with Renee on an alternative.
Okay, so what I'm hearing is, one, we still need to try to hone a parent document somehow, potentially. We don't wanna,
Right.
we don't want that to necessarily hold us up, however. There may be support among the committee about two different versions, one that supports the decision of the Seventh Circuit Court and one that supports the decision of the 11th Circuit Court. Is that
Yeah, if Sam has access to, or the will documents you put in here are looking at different precedents from a different lower court, I'm all in favor of looking at them and saying, yeah, that passes at least the red face test of, we didn't do anything willfully wrong. We may not be as liberal as this court, but we're not any more conservative than this one.
right?
And we
Thoughts?
some input on that. As I mentioned, we're litigating that for another district, choosing to go the direction of the 7th Circuit or the 11th Circuit. So we've helped to prepare some of those documents, and happy to give you our suggestions as well.
Thank you.
Thank you. Yeah, I mean, I have no problems with the thing, you know, I mean, at some point we have to do something. And so I think just pushing it to action and let the vote be what it is, I think is the right way to go. I'm sorry, though, I'm confused. I thought we agreed on the rental thing.
So he said parent.
A parent document, I mean,
Oh.
one that governs.
Yeah.
Yeah.
I think that's the.
I heard that soon, I'd scratch my head too, I'm like, oh.
Sorry.
Did that.
Yeah,
Oh,
no.
it was preferred away.
Right.
So Sarah, or Jared, if this is an administrative guideline and you guys create them and the board is generally aware of them and ratifies them per the policy we approved 2 or 3 months ago. Does this one need any action tonight or just our awareness, or how does it come up? Because and Craig, I'm not trying to, I think what we have to do is put this into action because we all agree that at a minimum, it's better than what we have, but that it's not done yet.
No,
Is that
no,
accurate?
I think we're divided on that,
Okay.
period. I mean, at least that's what I'm.
Yeah, I
Yeah.
mean, I'm 100% believe that there needs to be parent consent. I think legally that's important. I do think there are a lot of things that may still, I don't know if I want.
Well, I guess my bigger concern would be that there's still work to be done,
Right.
you know, and does this come back to the committee again before it goes? to the
Well, I
board?
understand. I'm just saying, if orders in hand, is that Sarah doesn't have to contact the parent?
I mean,
Is that what we
Don't
want
we
to
like
be?
meet this in place now, and then we can
That's
kind
fine.
of go back and revise it as we need to, like the whole good versus great thing, like.
I
Otherwise, what we have in place now does not match what we actually
just-
do, nor what's recommended.
I wanna. I'm not defending what's in place now, but it does say that it strongly recommends parental involvement. And I'm not saying that that's the words I want in the policy, but
Different, Greg.
You know.
I just didn't, I wanted to make sure that we all knew what Sarah and Jared would be doing if somebody calls tomorrow. And right now, there could be some ambiguity.
Confused as to why we would want that though, like, why do we not want something better in place?
I think we're all working for that. But, you're asking the opposition to part of the document to make a decision that's against their conviction to support a policy. And they're likely going to vote no on that. So,
Right, if there's no vote, they're supporting the policy that's in place, which has the same language.
By
Could I-
doing nothing, we're.
not the same language, lesser language.
Can I just chime in with an option that other districts have explored? And that is that if you have guidelines about how to navigate a gender support plan or a student support plan, whatever title the district chooses, one of the options is to stay temporarily silent on the issue of bathrooms. So I don't know if that's a fit for all of you tonight, but that's another option while the discussion is ongoing, in the event that you wanted to put those other pieces in place, but weren't ready to make a decision on the bathroom piece.
thank you for that. That sounds appropriate. If we were to omit the bathroom topic in this transgender guidelines and push that as a consideration?
Both what they're called, they are called the Student Gender Support Consent Form, and the other form, the Student Gender Support Plan. Both have an entire section called use of facilities in them.
Mm-hmm.
So if you're striking them from the administrative guideline, you got to strike them from that document, which leaves it entirely ambiguous, which means you're probably inviting more problems than you are by keeping what you have.
So
Because the next person who walks into a bathroom has no guideline and can do whatever they want.
right.
I would highly suggest we do not strike it from the, we may not like it. And we have every right to change it in the future, but to omit it is not gonna help anything.
I guess I'm a little confused because we're being told this is happening, so if we're already doing it, what are you know what I mean? Like, I guess.
So what we're doing right now is they have a choice of the three.
Yeah,
Okay.
but I guess
So, I mean-
to her point, like, what's the urgency to be able to to actually have a discussion at the next committee level
And this is
that
happening.
that gets a little bit closer to this, I guess.
I don't have any reason to strike facilities from the existing policy in the next, for just to cover 1 month. That I don't think we gain anything.
So what are you suggesting, that we ask the administration to come up with a draft policy on both the Seventh Circuit and the 11th Circuit, and just have a committee of the board? I mean,
Well, that was one of my suggestions, but if this policy is if this administrative guideline is 95% of the existing one, with the exception of parental consent, I say ratify it.
I don't.
And then we continue to work as we just more or less agreed to, which is having Sam and Jared draft one in consult of Will, as well as the 11th district and our attorney, to get one that is closer to the direction that some board members and some community members want it to go. But in the meantime, to stay mute on bathrooms, or to strike them entirely from the policy and the consent form and the et cetera, I think is dangerous. I just don't think it's prudent to take it out.
Okay.
So you all should make the choice that's right for you, so that you're aware. The districts that say silent on bathrooms, then that decision goes to the administration. So some boards decide that they don't want that decision to go to the administration. Others decide that for the time being, they're going to have it go to the administration. But that's just so that you're aware. That's how we've seen it operate when boards decide to stay silent on bathrooms, either temporarily or for the long term.
Yeah, which is what we have in place now.
I have an out of the box question. We have a gender support plan in front of us, the other plan in front of us. How is that any different than our DEP plans that we have for advanced learners? Not special ed bound by law, that's different with the IEP, but we have an advanced learner plan specifically which tailors their instructional thing. It gives them something a little bit different, but it's within their needs. How is this any different? So do we need to have administrative guidelines to be able to move this forward? That's my out of the box question.
Yeah, that's a good question, but
I don't see anything. There's law, yes. So does that make it similar to an IEP where you need guidelines, or because it's still somewhat gray? It's kind of like the DEP. I don't know if the administration has any guidance, if Renee has any, I don't know.
I mean, when it comes to IEPs and stuff like that, you're always going to have some sort of a guiding legal document that does that, right?
Right.
An IEP is because that's state law, yeah.
Right, it's federal and state law, and so that's different. And in terms of how districts handle this, again, all over the board, some districts have policy, Some districts have guidelines, some districts have neither policy nor guidelines, and they handle, they have forms that the administration uses, and it's all directed to the administration to implement in their discretion. So it's very, very, there's a continuum of different ways to handle it. But it's not like IEPs.
Right, I'm just wondering if this can at least moving those forms forward, so we're at a better place than we are today. And still honor the fact that we can still work the guidelines at a different.
I'll say this, I'm not voting for a policy that, is against my conviction. When it's not finished, I'm not gonna do that.
Okay, is there anything in the plan that we say that we don't like? Let's move to the gender support plan then. Is there something in there that we say we don't like? Because we're currently needing to do that anyway. We're currently doing these things anyway. It just gives consistency for building to building to building where we may not have that right now. So I guess I'd ask Sarah, is there anything on these plans that we're not currently doing? Yes or no? And if, I mean, you already said that this gives more consistency from the buildings. I guess what here don't we already do?
Sure. So again, while our practice was to have our parents and guardians involved in this, it was not something that was written down in stone that we must. And they're left a discretionary factor. This takes that out of the issue, right? We then, I chose to make sure that this document, that these gender support plans were reviewed and revised every single year so that they were updated, whether it is current, whether there has been a change, a concern. They have not been actively reviewed like that with the families and with the student, unless the student approached a student service member, okay? So there's some of that. When we go into more of the areas, I added a little bit more explicit verbiage. I added some information regarding the change of legal names to make sure that we are following legal policy, which is you can only do that if there is a court order. We have dealt with that in the past. However, it needed to be stated. Went through here and I added specific action items on the bottom that must be done. We must complete the gender support consent form with the families so that we have documentation that the families are involved and they do consent to X, Y, and Z. The sharing of the plan, the scheduling, the consent to, do a variety of things. We don't have any of that at this time. I wanted it to be very clear for our student services staff members, what they needed to do to make sure that they were following the law, because this follows the law as it stands.
So what I'm hearing you say is that this is everything that we've currently been doing, but we're also covering ourselves for the legal pieces that we didn't have documentation of in place.
There are pieces that we had not been doing. And so it creates a more robust plan that is very consistent with the law, and it is spelled out.
Okay, so I know.
There's so much on here though that we haven't discussed. I do think we haven't talked about student ID.
And let's discuss it today.
Dave is saying not to. The committee is wanting to come up with a new plan. I mean,
Well, basically, it's okay being here until
Okay.
midnight. Sleep.
How long
so
is it
maybe
still?
not. Right back over here.
I
I do still have.
But if this is something that we need and we can do right here, right now at the start of the school year, and the guidelines aren't a necessity to that.
What are your additional concerns, Lori?
we haven't discussed the WIAA. This makes it seem like we legally have to allow them. Title IX is still, I'm assuming we are not required to follow Title IX. I have questions about what WIAA.
We're
actually
enjoined
says.
from title, the current executive order, Title IX.
Right, but this is kind of saying are we allowing transgenders to go into the sports that they were not? it's giving them that option. Am I wrong? Maybe I'm misreading
So
it.
I can interject on the Kansas case and the injunction. So the injunction is against the U.S. Department of Education. So the Department of Education cannot enforce the new Title IX regulations, not all of Title IX, but the new Title IX regulations, including gender identity. They can't enforce that in those two schools in the district. And so that allows in those two schools, the board has a choice. Some boards will say, we're going to implement the regulations anyway. Others will say, we're going to pause. And others will say, we're not going to implement. So just so everybody is aware, in case you get questions or it comes up, the injunctions against the Department of Education and the board has a choice.
My understanding is that we were taking a pause.
Yes.
We already had decided.
Okay,
To
thank
your
you.
question. Renee, do you know what how WIAA lands on the subject of transgenderism in sports?
We know that they've got some guidelines, and we usually in policy, if a board wants to take make any kind of statement in policy or in administrative guidelines, we usually just refer to WIAA, because unless there are athletes for which the district decides it wants to challenge the WIAA rules. So most of the time what we see is just, we're going to follow WIAA for WIAA eligible students and activities.
What are those current WIAA rules?
So I'm not an expert in WIAA. I focus mostly on what the law says, but I can tell you generally that they have, they've talked about the types of medical information that they do, and they don't require, it's very specific, and we can get those details to you.
It's not just black and white. It is.
Well, January conference at WASB, there was 2 amendments to the WASB manual that were put forth that weren't considered by we'll call it the Board of Governors.
Mhm.
And one of them came out of Sun Prairie, I think, having to do with free breakfast for all the time. And then the other one came out of another district that wanted to specifically put into WASB guidelines and recommendations that I think it was to protect the women's sports clause. And WASB as a governing body, if you want to call it that, as a recommending body, maybe, they said, you know what, we're not going to take that up. We're going to defer to WIAA. And they recommended all districts do the same thing, meaning that kick the can to somebody else's problem. If you want to rule on it, do it. But WASB wasn't going to take an official position on the protect women's sports clause and recommended Wisconsin Association of School Board, which means they're leaving us all out there on our own to make our own decisions.
Right.
There's no recommendation.
And they have some, rules, WIA, I don't know if you want to call them rules, or they have the procedure if there is a student, if we would. So my understanding is it's a discretion of the school district to allow it at this point.
I wouldn't know, but so we
From
don't
what I
allow it, but then a
understand.
team shows up with somebody who's trans on a team. What do we do? Not let
There's
them
all
play?
And that's why WIA asks for people to disclose that if they are going to allow it, because let's say that the school district only allows males to play with males and females to play with females. Our females who are playing football, whatever, female football, they have a right to know if they are going to be playing football against a male.
So I just think
very
this is
important.
a little
So
bit more, that's my point. I think there's a lot of discussion that has to happen there. I know we can do it.
It's a bigger cultural discussion.
But
We-
in this though, besides that.
No, they do not. The
They don't
district
decide
decides
what we do.
that.
They don't decide what any school district does. The school districts decide and they
You can
just,
read
yeah.
it.
They don't
this-
bar anyone from doing anything.
In this plan, I don't see where it goes into that. If we take out under co-curricular activities, if we take out the 2 lines that descriptive under it and just leave the heading there
Mhm.
in that gender plan, if we took that out for now,
Mhm.
until we take care of the administrative guidelines, if we take that out, I don't see anything in here that gets into any of that stuff.
Agreed.
So based on what you were saying, the hesitation on this, that, if we remove that, does that remove that hesitation?
So to
That
remove
piece.
section V,
Not the section, go to page 3, co-curricular activities,
of the
Of the plan.
plan, yeah.
Okay,
where it says refer to the administrative procedural guidelines, transgender student, blah, 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 those two lines.
where's,
For the time being, until we get the administrative guidelines taken care of, because we have nothing to refer to,
Mhm.
at least we have that heading there. Sarah, does that take anything away from the document itself? And B, for the people in the room, does that at least satisfy our, does that take care of our apprehension?
For that piece.
For you, that was the one apprehension piece of why we wouldn't move forward with the plan.
Well, it was one piece.
Right, so
I mean-
until we put another piece out there, you know, we can only deal with one thing at a time.
So remove
The two lines under co-curricular activities, go to the top of page 3 under the gender support plan.
Yeah.
Refer to administrative procedural guidelines, transgender students for information on student intramural and interscholastic athletics, extracurricular activities.
Yeah.
If you just remove that descriptor, you still have co-curricular there, you still have everything underneath it. You just eliminated those two lines for the time being. And if need be, Sarah can put them back after we take care, you know, I don't wanna do anything different to the plan that you created, but does that at least take us, to get us in the interim?
I think it's still in the document though, section B under,
section V and the guidelines themselves. So,
Thanks right now, we're talking about the plan.
well,
We need a.
but they're
procedure.
connected to each other. You can't have one without the other.
We have a plan right now that's not connected to the guidelines. So I'm saying right now, can we at least have a plan, you know, a better plan in place? We already said that we need to look at 2 different sets of administrative guidelines. We've already kind of agreed to that. We're not gonna get to that today. So how can we do something better for our administrative team in the next 2 to 3 months before we have this stuff taken? Because it's gonna take at least 2 months.
Sarah, do we have guidelines currently in place? Do we have any kind of guidelines? Because my understanding was that
You mean
There-
like administrative guidelines?
prior to these administrative guidelines, my understanding was that there was a copy that was on a computer, and that was what Jared found when he was asked to look into it. So we do currently have
I
guidelines.
didn't realize we had.
Yeah.
Okay.
So the reason that we're questioning this is because currently, as it stands, we have like you said, Sarah, we have a less specific version of what's on our table tonight. We have the stuff that's currently in place is a broader reaching, vaguer version of these guidelines that you and Jared have worked on. We have a gender support plan that is less specific than what you guys have worked on, which, like I said, I appreciate that. I always want to give credit where credit's due on those things. But the reason that we keep on getting held up on it over and over again is because fundamentally there's at least one difference of opinion or more differences of opinion on the board currently about what would be the best model to move forward with that. And that's the reason that we keep on getting held up at every stage, because those things are all wrapped together. The current guidelines, the current support plan, the proposed guidelines, the proposed support plan, that's all going to be wrapped together for the entirety of it. And the reason that I come to these as a non-committee member is because this is where the majority of the conversation happens, and we have huge board meetings already. The conversation needs to happen here, right? Just to clarify, I'm not trying to draw things out.
I guess my question would be to administration, whether or not they would have the bandwidth to move forward with those 2 different drafts. It sounds like our legal counsel has some language already potentially worked up that might allow for that to occur. Is that possible? We can put forth those two proposals or recommendations for the board for the next board meeting, and just happen to have a discussion of the whole on that particular topic, and then
And before they answer, Craig, I'm gonna ask, not that our precedence is relevant, but when we've had somebody sponsor most of the time a policy, but let's say in this situation, sponsor an administrative guideline. It's worked pretty well. I mean, whether it was bullying or veteran affairs or not, honorary diplomas for veterans and deceased class members. Tina worked on extracurriculars. Diana was working on, I forget, that one got punted a couple times. You had one as well. And if Sam wanted to, let's say it's the next policy we talk about. If Sam wanted to sponsor one, we'd give it to that other board member and a member of the administration to work on it and bring it back to the next policy meeting. I don't, as contentious as this one may be, there's no difference in what I just stated in the bullying policy that Lori worked on. And I was only advocating that Sam do exactly that. Sponsor this, take it back, work with Jared, work with legal, work with Neola, and propose an alternate with them side by side. And my only comment, my only pause in any of that is what's the order in hand? And you're telling me you can't even get behind this document, even though it's better than the one we have, because it's got a language objectionable to you. On the flip side, you also agree it's better than what we have. So we're at an impasse.
Yes,
we're happy with Sam moving forward with a different one. We like what we have, but we don't want to end this meeting until we alter it to be perfect. And I'm saying we're not going to get there.
I agree with you. We're not gonna get there.
So then we have to, which one do you want? You want the one that's currently available online and even more objectionable than the one in my hand? Or do you want to say Sarah and Jared work with this one until we get a better one drafted by Sam and ratified by the board? And your call, you're the chair. I'm just telling you, you got to pick one.
Right. I would be supportive of the sponsor process if that works. If Sam, you're willing to sponsor that. I don't know if the rest of the committee is supportive of that thought. Sounds like David Schrader has his.
Good with it.
I'm good with it.
Okay. All right.
And then it's a matter of, do we need any action on this administrative guideline? Or does that action leave Sarah and Jared kind of in a limbo?
Well, it would suggest that the current administrative guideline, which has not ever been approved by the board, still stands.
So why don't you just take out the one clause in D about the bathrooms and then pass the rest of it? Maybe take out the clause in D and then the.
No, we've discussed. that.
Okay, yeah.
It's creating a lot of extra work for, so.
Right.
No, I understand. It is really a rock and a hard place. It's a difficult spot to be in.
And I'll just say, try to be more right than wrong, Sam, when you put it together.
I think I'm pretty clear as to the direction we're going here. Direction we're going is we're gonna craft an alternate that aligns more with the 11th Circuit.
Mhm.
Sam, if you can get me your notes,
Yeah.
I will get them through Sarah to Renee. Sarah and Renee will come up with a draft for you to overview,
Mhm.
and then we'll bring this all back to the next committee meeting.
Yeah, I think that's the best act to take, honestly.
And Sam, you're the sponsor. I trust you on it. I would just, let's not try to, if the 7th is here and the 11th is here, let's try to keep between the two. I don't know. I don't want to be dipping my toe on the other side of the 11th.
I get what you're saying. Yeah.
I mean, I don't know what that would be.
Yeah.
Because I don't know what their policies and that precedence is, but.
Yeah, so what I
we
understand.
can write Title IX if we want.
Yeah. So what I understand of this board, right, is we're not of the ilk of a school district that is so far one way or another way politically because they feel like their community is that far one way or another, at least the majority in the community, that they're going, to be, advocates. They're going past.
I don't want to be bleeding edge on either side.
Exactly. That's what I mean. I think we've always, as a district, been in the middle and basing our thoughts on law, whatever that is, whether it's the, politically left side of the law, politically right side of the law, but we still have basis and we haven't been advocates, right? Some other school districts push the envelope to be advocates. I haven't seen that from this district yet. And if we're changing that, then I need to change my work product that I'm bringing to you because I'm hitting more of the, the idea of here's what things are in place, here's things to think about, and this is where you need to go. If you want us to get into advocacy as an administrative group, then tell me which direction that looks like and how are we going to get there. And I will bring you that work product because that's what I'm hired to do. But I think I can hit what that middle looks like from the 11th Circuit Court side and bring it to you and say, this is what this proposes to be. Okay.
Okay.
And you guys can then vote on which side of that as a board collectively you fall in.
Thank you for that. Any further discussion? Too bad. Thank you.
It's quick, no wait time.
Let's go ahead.
The consent form, because this is something that we do not currently have.
No, we're actually gonna be under our regular guidelines as they were. I mean, we're not moving forward with any change right now.
Thank you. Renee, are you able to stick around for this next one?
Sure, yeah, absolutely, I can.
Letter B, we have non-discrimination and equal employment opportunity. That's policy number 3122. And we had a discussion about staff ethics at last meeting. Those two policies are going to come back. We see the information regarding an email correspondence with Neola, and they I'll see here, what do they say? The committee would like to see the current district policy verbiage included in the Neola version of the policy. However, they would like to find out if any of the district verbiage is problematic or conflicting with Neola before it is added to the Neola policy. And I think the response was, shoot, I lost it. Yeah, it's at the bottom. I'm not sure I see.
Yeah,
The question regarding policy 3210.
Yep, okay. I think you could add policy, okay, 3110, 3210 and 4210. It appears as several of them may overlap, so I would take care in adding if there are statements which are similar intent and content. In those cases, you would probably add either the district or Neola, whichever you prefer. Although the closer you stick to Neola, the easier updating would be in the future. That's Neola's response. I'm sorry.
Yeah.
Is there? I guess the question is,
say what's your question?
My question was, is there any harm with sticking with our current verbiage, district verbiage in the policy for staff ethics?
Why don't we want an updated one? Like, why would, because I just don't know why we wouldn't want an updated one, because wouldn't that be easier for Neola to update it as it updates?
Well, keep in mind, that discussion was that our current existing staff ethics policy was quite lengthy, and not super lengthy, but it was more specific. It happened to have more things that we had identified as being important enough to call out specifically for ethics concerns than what Neola's was. I felt ours was a little bit more concise as well, but I mean, so I don't know if Renee happens to have access to that policy.
I believe she does.
31.
I haven't seen that before. I mean, we can absolutely review that if that's helpful to all of you, but we haven't reviewed that. I haven't. Has somebody else in our firm, do you know?
I don't believe Emily has reviewed this ethics one. And that was because the board directed some things to our legal firm and some things to us to have questions from Neola. Basically, what I think has happened is we got a response from Neola. And the response from Neola is you can use either one. But we prefer you use ours because it'll be easier for updating in the future.
Okay.
I mean, that was the response basically that we got back from Neola. The question is do you want our attorneys to review it? Because that would be a different set of eyes, and proffer an opinion.
In my 2 cents, I mean, I read through these, I didn't memorize them, but there's, in my mind, there's not a material difference. And I say material, I'm not saying it's not more specific and there's not more examples, I'm saying materially, there's no difference, in which case, go with the one that's the easiest to keep updated, easiest to implement, easiest to understand, and let's move on. To split hairs on non-material differences, Craig, if you want them, take them. You'll have my vote. I'm just saying, then let's do that. But I'm not
Spend
gonna.
as little time as possible.
There's no difference, Sam. Yes.
Yeah, I know.
Basically, Neola said there's no real difference. You
Neola
choose
said
which
it's
one.
okay to do. So,
Yeah,
yeah.
if you wanna put it forward, we'll put it forward, but
Okay, I mean, is there any objection to moving forward with 3110? All right, like our old
version of
staff
instead of this.
instead of Neola.
Wait,
I
I
would
would
too,
prefer to
that's
go
fine.
with Neola's.
What?
Because I would prefer to go with Neola's. Because if there's not really any fundamental difference that way, you know, I think we have to look long-term as well, just as far as like, okay, if Neola is gonna be able to update it, like, boom, they can update it. Otherwise, they're gonna have to pull this out separately, and whose job is that gonna be?
The
to-
committee's job.
Well,
There's a lot of
we'll see what their updates are gonna be, and then it's just a matter of a discussion and then plug those changes in. If code ethics changes, you know, then okay, we'll have that conversation, but I can't imagine that there's gonna be much compliance changes with ethics. I mean,
They're gonna say, actually, you are allowed to politically proselytize students. No, that's not.
I don't
So
think so.
think that they're gonna take issue with specifics that are in there.
Yeah.
Just throw in some extra stuff.
So. I don't know. So Tina would prefer to stick with Neola. Lori,
The old one.
okay. I guess we'll move forward
I'm
with,
not gonna die on either hill.
okay, we'll move forward with the old ethics
So we're gonna. pull
language.
The old.
Pull the old language, put it into the new number,
And then just remove
their language.
All right, which actually brings the question that several questions regarding the non-discrimination and equal opportunity, equal employment opportunity. You see the response there from, was that Neola? Golly, why is this?
There was Neola and the attorney, correct?
Neola and the attorney. Regarding. Wait,
Was it just the first paragraph, portion in parentheses, was that a major difference?
That was, I think, the
The
question.
question was on page 3 of 3122. There's the second paragraph under reports and complaints of discrimination and retaliation. They wanted to know why this is written this way and clarify what parts of the policy are legally required.
okay. I appreciate that. And I will clarify the question that I actually do have that wasn't explained in their response. But I don't know, I wanted to give Renee an opportunity to speak to what's already been proffered by them.
And Renee, Emily from your office did respond to Margaret under policy 3122, non-discrimination language. It's in the supporting documents there. So you can
Email attached.
you can see her thoughts on that.
It's the WUSD email forward policy 3122.
Yeah, I can see this up here. I could look for it, but anyway, I can just give you an overview if that's helpful. So I can see here that this language has gender identity in it. And so if that's the heart of the question, and is it required, as Emily will tell you regarding Title IX, there's not a requirement that yeah, so I think I think what might be helpful is that if the committee and then the board decides they want to go a certain direction, then we can absolutely support that direction with language that is consistent with, if you want to go with Neola's language, there's other language that's recommended other places. And if somebody asks us, is that okay? Yes, that's okay. You can do that. So in other words, the new regs in Title IX and, the injunction and all that kind of thing, you still have the choice. You have the choice of moving forward with language that would be consistent with the new regs, even though not required by them. You have the choice of pausing, and it sounds like you're pausing. So there's also the opportunity to say, we're not going to do that yet because we're pausing. So all those policy choices exist. And then once we know what the policy choice is, then we can say, okay, here's the language that would be consistent with that policy choice.
Hey, Renee, this is Margaret. This email is related to our anti-discrimination employment language, not related to the Title IX policy language. And there was a question as to whether the Title VII language included things like gender identity and things like that. So it was more focused on Title VII, not on Title IX.
Got it. And so when we're looking at general non-discrimination policies, that's what I'm talking about. And Emily can speak better to the employment issues. As many of you know, I'm student services, so I don't get into the employment issues and always ask that she weigh in on that. So that's my overview of how we're handling the Title IX stuff. But Margaret, I'm glad that you interjected, because if the policy that you're looking at right now has to do with employment only, then I would defer to Emily on that piece of it.
And she responded. Sexual orientation is a specific protected class outlined in state law. So we want to keep that reference in there. However, gender status, change of gender, and gender identity are not specifically outlined in state law. While Title IX arguably covers these categories under the protected class of sex, you would not be required to include these specific terms in your policy. Additionally, the pending Title IX litigation could have an impact on these terms as well.
Right.
So it seems to be that she clarifies that pretty decently.
I'm sorry, what's our issue with that?
So I will say, I think I tried to email this question, my questions regarding some of the language. It was actually the second paragraph, that particular paragraph that was contained within. So I said, I'm not sure my questions were answered, but discrimination, that section, discrimination against an individual based on their sex, including gender status, sexual orientation, and gender identity, is discrimination of Title VII, specifically discrimination based on sex stereotype, gender nonconformity constitutes sex discrimination. This is true irrespective of the cause of a person's gender nonconforming behavior. Employment actions based on an individual's sex could be suspect and potentially impermissible. So along with that section in parentheses, which I feel gratuitously references gender status, my concerns pertain to the last two sentences, and that's what it says. Specifically, discrimination on basis of sex stereotyping, gender nonconformity constitutes sex discrimination. This is true irrespective of the cause of the person's gender nonconformity behavior. Employment actions based on an individual's sex could be suspect and potentially impermissible. So that takes on the tone of the particular Neola policy that moves on throughout the disciplinary actions that the district takes. So I felt, as a board member that is sworn an oath to uphold the Constitution, I am concerned that this line ultimately gives deference to an individual that has gender identity complaints, while at the same time restricting one's First Amendment rights of free speech through compelled speech. Compelled speech is a complex issue, and the references provided by the EEOC are seemingly more lenient than our policy as written, than this particular policy. Then under section 11, it says, could the use of pronouns or names, this is from the EEOC, could the use of pronouns or names that are inconsistent with an individual's gender identity be considered harassment? And then it says, yes, in certain circumstances, unlawful harassment includes unwelcome conduct that is based on gender identity to be lawful. The conduct must be severe or pervasive when considering altogether unwelcome conduct based on individual sex, including identity, thereby creating a work environment that a reasonable person would consider intimidating, hostile, or offensive. So very specific language from the EEOC. So in that response from the EEOC, they clearly indicate that the conduct must be severe, pervasive, and repeated. Yet this proposed policy takes on the tone that it's a zero tolerance policy, where one can be fired for refraining from compelled speech. So at the same time, the policy does not seem to remedy the situation where two individuals that are not gender conforming provide a complaint against another. So that's opening up Pandora's box too. So my main argument, question, concern is this: would it give the district the most amount of flexibility and reduce the liability regarding the constitutional questions by omitting those particular lines, since the protections are provided to individuals currently under law for discrimination, which is also acknowledged that the state has not added to statute? Why is there a need to provide deference to a group of individuals over another group who have convictions to reserve their speech? So that would be my question. That's my main question. And you'll see in the examples and the agenda under administrative guidelines regarding transgender students, I included model policy number 33, the employee use of student pronouns, and that is Will's model policy that also seems to lend credence to what I'm concerned about. You know, specifically, the district will not discipline a teacher from refraining from using the preferred names and pronouns of a student if doing so will conflict with a teacher's sincerely held beliefs. So
Okay, so there's a lot going on there. So are you saying that paragraph goes against First Amendment rights, and so what Neola is recommending goes against First Amendment?
I think it omits First Amendment or the First Amendment protections of individuals that want to refrain from using pronouns according to their teacher's sincerely held beliefs. And we're here to protect the Constitution. That's to uphold the Constitution. Well, that's what you swore an oath to. So
I mean, I'm asking from the standpoint of, because, okay, so and I'm sorry, I'm just legal counsel in this area might be able to speak to it, because I guess I'm trusting that Neola is giving us the, like, what needs to happen.
And I'm raising a question that they're not.
So I can add a few things. I have reached out to Emily to see if she could jump in, and I haven't heard back because she didn't have this on her schedule. But we're absolutely happy to give you additional information. One thing I can say right now is that that issue that has just been raised regarding the teachers' rights, and that's what we're going to see litigated in the Argyle case that I mentioned. So there's a teacher who raised that concern, and that's going to work its way through the courts. And so we'll know more through that. We do know that there's going to be a conflict between parent rights, because parents have the right, we know from the Kettle Moraine case, to be able to direct what their children will be called and the gender that they will, that will be acknowledged. And so then, we've got those competing rights. And so this case is going to be about that. So I can tell you that from a general perspective. And then the other thing, just generally, that in our experience with Neola, is it's really great to have these bases. It's great to have a start. And we frequently will weigh in on different options that districts have, because you have a lot of choices in terms of, like, going back to what I said before, the policy decisions that you're going to make. So there's times where the Neola policy will match the policy decisions the board makes, and other times where it may not match. There's times when administration will say the Neola policy is working great for us, and there's other times the administration will say, well, we just tried to implement this and it's not working out for us, so we need to make an adjustment. So there is some flexibility, and like I said, we're happy to weigh in on this further when we get some input from Emily.
Okay. So I guess
Down for now?
at this point in time, we don't have the questions the answers to the questions that I asked. So I think we move forward. I don't know if it makes sense. My suggestion to the committee would be move forward with the staff ethics that we had mentioned earlier as is, but then policy 3122 for non-discrimination, equal employment opportunity, we postpone that for the next committee meeting.
Perfect.
And in postponing, the action step that we need is to contact Emily and to talk about speech provisions.
Right.
Held
Well, I
speech.
think
Is that what you're asking? Right, I wanna know so that
Yes.
I can get you what you're really looking for.
I mean, the questions that I really like to have those questions answered. Like why the omission of acknowledgement that staff happen to have a First Amendment right of compelled to refrain from speech.
Okay. And so your concerns are outlined in which will policy that I could put in
policy number 33.
Okay, so I could say more in line with policy 33 from Will.
Correct.
Right? There are some questions about Neola's verbiage, and does it give the same protections that policy 33 would give for staff for free speech? Is that what you're asking?
To refrain from compelled speech. So
sure, yeah. I mean, that means
I think there's some
different things
extra
about
words
the,
that got put in this
Mhm.
that necessarily aren't
well,
Title VII.
Yeah.
Am I right?
Let me
So
ask this,
that's what I
Renee,
think
do you think you can help convey to Emily what it is that we're asking?
Yeah, we work as a team all the time. Brian, Emily, and I, and then Dan is part of that team, for the time being until his official retirement. But we work as a team all the time, and so this is an issue that comes up really frequently, and I just don't want to speak to it without being an employment expert. So yeah, absolutely I can, and I'll let her know that this is on your minds and that you need additional information, and we'll get it to you.
Thank you. Appreciate that.
appreciate that.
Yeah, of course.
Any further discussion on that topic?
Yeah, just Renee, when that happens, and I know Emily knows this, make sure that the response when it comes back is carbon copied to Margaret and myself and Lynn here, because we're the ones trying to pull all these things together for the board. So.
Absolutely, I'm making a note of that right now.
Thank you for your late night, Renee. We appreciate your presence.
Thank you.
Oh, I'm happy to join you, and we'll keep doing what we can to get the information that you need. And if other things come up through your meeting tonight, just let us know. We'll follow up.
Thank you.
Take care, everybody.
Take care. Thanks, Renee.
We're at letter C on the drug-free workplace. This was coming back from the previous session of policy. I was just kind of curious if Margaret may have some further clarification on this one. Do we lose you, Margaret?
I believe this was a Neola review.
The drug-free workplace, actually, I think there were some questions about that.
But I don't remember.
This is whether or not the verbiage should be stricken, what the positives and negatives are, and what, if language might be recommended.
Yeah, this one was supposed to be a legal counsel review.
Oh, yeah, but the supporting email there again was going back to non-discrimination.
Right, but, and there, the reason why I added it here was because if you look at this one line here, it said we are comfortable with the changes to policy 3122 and 3122.01.
Oh, I missed that.
Okay,
So I don't know.
I was confused on that too. I thought.
Yeah.
But then you touched it twice.
No.
Thank you.
No,
Yeah.
they just answered both things in the one email.
Right.
Yep.
There you go. Thanks for that.
Yeah. No problem.
so, I mean, that one I don't think deserves a ton of discussion on, but I mean, so we have our if we're happy, if they're content with the changes in the language, we have is there anybody opposed
And that
to
was
moving
just
forward?
striking of the awkward conduct or what was the?
Well, yeah, remind,
Yeah.
which one, what is the?
I don't remember either, that's
I
the thing.
missed June policy, but.
I was here, yeah.
Yeah,
I think I was here.
It was the striking of disciplinary action that may result if a staff member
Mhm.
conduct
Pretty
is
sure that
being
was-
depicted, yeah.
and
Put it this way, I read through what's here and there've been less the redacted portions. I was okay.
Okay,
I was okay with it. I'm okay.
I'm good with it.
I know I think that was a question that Margaret had, but I'm not sure, but nonetheless, if we're happy with or content with those changes, then I'll move forward as a recommendation. All right. 2120, we're just still cleaning some of the stuff up. Was set aside to get some clarity on the verbiage with the HR department. Is ready to be looked at for first read.
I'm sorry, where are you?
Which one?
this is 1220. This is one that we to give you the background information, I asked when we were talking about this in policy committee, when we were taking on 1200s, I said, let's make sure that we double check this compared to contract language that we have in place.
That's right.
Because we didn't want a policy, right, to have any changes that would enforce changes in our contracts that maybe you didn't want. Margaret did have a look-see, and we're able to go forward with what you see here. So it
Rubber stamp.
yeah, it just goes along with I wanted to double check. I didn't want this policy to come back and then all of a sudden we are coming back to you with all the administrative contracts and going, guess what? You guys just made a change you didn't know about.
Yeah.
Right? And so it works, it meshes, and now we're bringing it to you.
Perfect.
Yeah.
I'm
good.
fine with those changes. I was anticipating that much of this would go very much the same way. So what you see in letter E and F, you see the 3,000 group 3, and then you see a 4,000 group 1. The 3,000 group 3, there's a number of policies that don't have an existing match. There's a couple that may actually have some discussion or question about. But on letter F, the 4,000 group 1 policy, those are actually policies that are they're mirror
to the professional staff policies, but they're the support staff policy, sister, brother, twin, whatever you want to call it. And so you've already passed the language in the 3,000.
For first read, it's in
Right.
second read this month.
And now we're asking you to do that same thing for the support staff piece. Okay, and so you'll see a lot of that as we go from 3,000s into 4,000s. There may be small differences because professional staff have certain things according to contract that support staff do not. But those would be the only difference, really.
I gotta change things up a little bit here tonight. I reviewed them.
Yeah.
And there was not something that I found objectionable among all these policies. But I don't know if somebody else saw anything in their review of these policies that they want to bring forward for discussion.
In both groups or?
In both groups.
No, I didn't.
The ones that didn't have a matching USD, I'm gonna say that I trusted Lynn and Jared to, move them over. The ones that had a comparable one, I read through those. I compared them to what we had to make sure that there was nothing drastically different. So I was taking under the assumption that new is acceptable and different might be problematic. I didn't see any problems in the 3 or 4 that I reviewed compared to the old ones, but I'll say that I didn't read every single one of them that didn't have, I read creating a position and I fell asleep immediately. So I figured it was probably safe to take it. The other ones, so I didn't, I mean, I'll approve them, Craig, but I didn't read through every single one. I read through the ones that had a comparable.
There was one about, there was one question about educator licensing, regarding the tier 1 and tier 2,
Yeah, I wasn't familiar with that, so I
difference.
didn't really know.
do
how to
you
make
want
that.
licensing?
So Margaret, do you wanna go through the connects to the law with the licensing tier?
So first of all, I just want to say that is rare if we ever hire a tier 1 teacher. So that is, for lack of a better term, like almost a temporary dead end type of license. You'd have to go back and begin tier 2 preparation in order to really advance to get a permanent or a lifetime license. So we try pretty hard not to hire tier 1s because they're very limited in time and in practice. So other than that, we do comply with the DPI licensing as it relates to tier 2 licenses. And I mean, we have that going on right now where we are essentially cooperating with a tier 2 teacher who is seeking either additional certification or certification in a different area. And in order to do that, we have to verify that the person is enrolled or in some type of formal program that will lead towards achievement of the additional license. We have to verify employment, and we have to provide clear and convincing evidence to DPI that we are monitoring the situation. And tier 2 licenses need to be completed within 3 years. So by the end of that 3rd year, we need to verify that that person has completed all of the requirements that DPI has imposed on that individual for whatever license we are working with them to achieve. The license types themselves do change. For example, we have somebody working on a tier 2 that's going for bilingual certification. We have had success with a couple of our teachers working under tier 2 licenses for special ed. So this is just really a summary of what we do to comply with DPI while somebody is under a tier 2 license.
All right, well, thank you. It seems like it gives HR the flexibility that they need to handle those particular situations. So I guess there's no objection for me on.
I just have one question.
Sure.
On 3120.08, employment personnel for co-curricular, extracurricular activities. The only question I had was that stipend was crossed out and pay was inserted. And so I know we refer to, I think as far as HR lingo and things like that, we always say stipend. And so I didn't know why to change, if there's a reason behind it, or if it's just we're going to change everything to that.
Margaret, you want to share?
Yep, I'm just pulling it up here. Tina, what was your question? What paragraph are you looking at?
It's 3120.08.
Yep.
3rd paragraph.
Yep, it's the
Stipend,
3rd paragraph. It has stipend is stricken and pay is put in there instead.
Well, I mean, we have, as some of you know, a couple different terms for additional compensation. We use stipend for some, we use special compensation for others based on like the background for, or the source of where the extra pay is coming from. I mean, I will say that we, from an operational standpoint, use that terminology for anything that's beyond base salary compensation. I don't know if that helps.
So pay is just a broader term that incorporates the different kinds of pay. A lot of what we do is stipend pay for those kinds of activities, but there are other pay sets that we come into that we utilize. So,
Right, like if a coach.
so
wasn't
we're just using a
employed,
broader term
Right.
instead of a narrow
They
term.
would be getting paid.
Does that make sense? Just using a more broad term than a narrow term
Yeah, that's fine.
because it helps the policy.
Oh, okay.
I mean, it just helps us to be, I don't want somebody coming in and go, well, says here that we have paid a stipend. My pay is not a stipend. Am I supposed to be getting a stipend too? If you use pay, it can mean stipend, it can mean bonus, it can mean any kind of remuneration that we can think of what pay source it comes from.
For the employees, so they know that, hey, they got paid for their coaching.
They do know that because in their letter of agreement, they know what the total pay is going to be.
Okay.
Okay.
We do also have some over and above activities or extracurricular or co-curricular activities that are paid on an hourly basis, on actual time worked, as opposed to a total stipend that's distributed over a number of pay periods. So using the pay terminology does allow for broader application of pay practices depending on the circumstance.
Good, thank you.
Did you have any other ones?
I just had one other one, and I am really sorry. Okay, so
What?
back to letter B.
Letter B?
Letter B.
On the non-discrimination?
22, yeah.
Oh, okay.
My apologies there.
Well, let's
No,
get it.
it's
We want to hear if there's other questions that I didn't raise.
The question I had was page 5. The third paragraph.
3122.
What's that? I'm sorry.
3122, yeah, letter B.
22, page 5, third paragraph. I know we had talked at one point, I don't know what policy it was or anything like that, but we had talked about, like, this one says 5 days is crossed out and a reasonable time period is put in there. Where I know we talked about wanting specific timeframes in certain things, but like I said, I can't remember if it was a different policy or what. Because then the first paragraph after the word or, so farther down, there's also one that 5 is crossed out and 10 is put in.
I remember
Which is
talking
fine.
about
we
this.
did.
So I remember us talking about days and making sure that things were gonna be consistent. And so I just had found,
Okay, so what we will do is we'll double check the verbiage that Dan DeLeet gave us to
Okay.
talk about days for different.
because we,
Policy
yeah,
pieces.
it's like one part missed and so
Yeah.
it was gonna go
Yeah,
back. So that's where-
we're going to where we can. Try to be as consistent across all of our policies for timelines.
Right,
And so we will just double check that and make sure if it's different as we move it forward, that's fine. We do know that this one is being postponed anyway, so we can also do that
Right.
double check.
yeah, that's fine,
Yep.
that's fine.
Yeah,
That's
Thank
fine.
you for bringing that forward. We'll double
Yep.
check it.
I'm good, thanks.
I remember having that discussion, because
Yep.
what you don't want is to push yourself to a limit that you
That you
can't
can't,
reasonably
right,
reach, and then you're
Right.
asking for, so.
right. We want to make sure that we're consistent.
Yep.
So I guess we captured the other action item on 3122 just now, right? Okay, good.
3122 is to make sure the timelines are consistent with other timelines.
Excellent. Did any on letter E and F? Okay.
Hold on, let me just find it. It was, and I don't know if it's necessarily regarding where is that? Athletics.
Oh, we're on,
ENF, okay.
yeah,
We'll see ENF in the agenda.
sorry about that.
Okay. Wasn't athletics in here somewhere? Or am I thinking of a different group?
There,
Is that in group
Five,
three?
3, 3, 1.
Thank you.
Quick line down.
I think my only question, I don't know why I can't find it.
I think it's
Oh, there it
it's
is.
in the 3.
It's right, 'cause it says
even though it's a 5.
I know we've been talking about the, and this is really, I'm not even like
whoa,
specifically,
wait.
oh, sorry,
Sorry, you're on 53.
31, it's in here.
Yeah, I think that was put in there as an indicator that this was a match of the proposed policy. So, but I mean, if you're going to reference that particular one, you're gonna want to reference the co-curricular activities one, that 3120.08, and make sure that that the question that you have lies with 3120.08.
Okay. Sorry, I don't know if it will, I guess I was just gonna ask, because when we talk about WIAA, where I get confused is because we have sports that are not in WIAA, so it may be another time that we need to have that discussion, but I get a little lost in translation because I don't know, and when you're looking at, okay, so don't look at 5, so we're not approving.
Yeah, we're
5331.
moving away from that policy of the 5,000 one. And into 3120.08.
Perfect, okay, that makes, sorry, I missed
Okay.
that, that's where I got.
And 3120.08 talks about coaching and activities, basically all sponsored activities.
Perfect,
Not,
okay.
not WIA.
Sorry, I was
It doesn't have the WIA language in
even
there.
until it's 8 o'clock.
Sorry, we're getting through it.
I remembered reading through it and I was like, did I have a question on that? So I just wanted to be sure I didn't miss my opportunity. Perfect.
Right.
Okay.
Any other questions on those?
And then we're gonna get rid of the driver's education one, right?
Yeah, was
That'll just get
thank you for
eliminated.
mentioning that. We just don't happen to have staff,
Mhm.
they're third parties, if there's anything and it's outside of our district jurisdiction, so it didn't make sense to include that policy as I understand it. So,
Okay.
the letter G, wait, David? Okay, letter G on the agenda, I just included in here, in case somebody else had further discussion about the development process. We couldn't quite get through the 30 to 35 that we aim for because, well, there's a limited amount of bandwidth, but we came close.
Very, very close.
Yeah, so.
I mean, if you look at both sets and the other work that we did on the top ones,
Yeah,
very close.
so,
So do we need to set up a meeting for, is this our regular month or non-regular month? I can't keep track anymore.
This is our regular.
This is the
month, so I
reg-
Sent an email.
right.
Yes, we
Okay.
proposed 2 dates, the 8th and 9th of September.
That
As
maybe-
different dates, to possibly have.
I'm sorry.
Literally, I've gotten more emails in the last,
So we're wondering if you're available the 8th or 9th,
No, it's the 9th.
or, oh, it's 9th or 10th, okay, 9th or 10th, so,
September.
yes.
I remember.
Hey, for September's a Sunday.
No,
No, 9th or 10th, well, I was wrong. You wanna point it out again? Okay,
I just want to make sure I'm available on the 9th and the 10th. I can point out again, right?
yeah, I would assume, like, anybody else wanna take a stab at me on
Somebody say it, I wasn't listening.
9th or 10th, I was in error.
Fire away, 9th or 10th.
I know that typically, I don't know if it applies now or not. I know Tina seems to have a challenge with Tuesdays, unfortunately.
Correct.
It didn't, my response was that either Monday or Tuesday would work for me.
Like, okay, so there's things you have to think about here. A lot of us have a number of different things,
Get married then.
a number of different things within our September to try to find a date before the September board meeting. These are the only two dates, and I will tell you, in giving you these two dates, both Lynn and I again are, impacting some personal items. So, just want you to know that.
If Tuesday works for everybody else, I just will jump out.
I'll be the scribe for you, Lynn, if you get available.
So is either 9th or 10th?
I don't even do, but I.
We're good.
Either the 9th or the 10th.
We could do it the 9th, that would be awesome.
If
I would prefer the 9th, because otherwise it's 2 meetings in one day. I don't know if I want 2 meetings. I don't know if I want to be with you people quick in one day. Kidding.
I mean,
And service, it's
we
early.
would
stuff.
prefer the 9th as well.
Okay.
Lynn and I would, but it's up to you guys. I mean, but those were literally, when we sat down with
Yeah,
calendars
no,
and
I
everything, those were the only two dates we had available.
I don't
Does the 9th work for you, Tina?
Monday.
I'm not for sure.
Okay.
The 9th work for you?
Either one.
So I guess we'll put it down as the 9th. Hopefully Tina can join us. And we'll move forward with that. Any other questions regarding the process? All right. We'll work on it. That's all I can say.
They're gonna adjourn, Craig, you come in, I think, or was it the planning on Monday was 2:40? I got Ed Services done in 2:35. You're at 2:38, so you're rating the sweet spot.
Well,
Pretty consistent.
Way it started. I didn't think we were gonna be out here before 10.
hey, we'll quit stalling and we'll get done with this. So it's 8:09 now. We stand adjourned.
And tell me twice. I'm not here. Last person.